Welcome back to court, folks. Today, we've got a fiery creditor's examination. The defendant insists he was never properly notified, while the judge pushes back with proof of service. This clash is all about responsibility, excuses, and whether justice will finally be enforced. Stick around, this one gets messy.
Okay.
Harry Brewer,
What's your name, sir?
John Thompson.
Okay. Gentlemen, this is the date scheduled for a creditor's examination. So what's the problem?
What happened to the set aside I paid and I did a set aside default judgment motion and all of that? I mean, I wasn't even properly notified to begin with. That's why I got into a default judgment. It's not that I was disrespecting anything. It's just I didn't know. And then as soon as I found out, they didn't mail me the original that he mailed me saying that he wanted my information. That's how I found out. And then I rushed right down here and filed the set aside default judgment and paid. And then I don't get it. All of my rights, I'm not afforded all my rights. He's getting all his rights. I'm not afforded all my rights because I wasn't properly notified. And then I'm willing to participate. I'm willing to pull my weight and do what the that you order, but can I have a fair shot at this? Please.
Sir, who are you saying is depriving you of your rights?
I wasn't properly notified and there was a default judgment.
We don't do anything. Let me just tell you this. We do not enter judgments without proper service. Now, I don't know what happened in your particular case, but our clerks have to go through and make sure that the documents related to service are there.
Here's the first dramatic turn. The judge calmly explains the court always requires proof of service. But notice the defendant's tone. He's painting himself as a victim of trickery. The judge doesn't buy it for a second. Already, tension is boiling.
So I can try to take a look and explain to you what may have happened in your specific case. But, to say you've been deprived of your rights, we don't do that.
Okay.
Okay.
Well, wasn't like, so how could it,
Start. You could be served and still don't know. And that's proper. It could happen. Okay.
So this is trickery then.
Okay. I don't know what you want to call it. Let me tell you what we do. Let me just tell you what we do. We have a book that we found. It's called the Michigan Courtrooms. Okay. It's right here. And it talks about how to serve process in the book. It talks about it, and it's for most of our general civil cases. And it's a little bit different for small claims cases. My understanding is this was a small claims case. Okay. So let me look and see what happened here. Because here it says a proof of service was filed here. And it specifically says on the affidavit and claim that the court will schedule a hearing once the defendant is served. So we don't schedule hearings until you're served. So let me talk, please. I've heard enough from you to understand what your position is. You have to give me the courtesy of trying to respond. So we have a proof of service in the file that says you were served personally by Mr. McPherson, who was one of the court officers that serves process, back on October 18th of 2024. Okay. So.
And she told me if
What?
I went forward with that proceeding, that I would get 7 days to object. And then they were gonna have a decision when you went to the window, and there was no decision. They said they would mail it to me.
Okay.
So this is
So would you like me to finish going over what I was going to do? I understand what you're saying. So that was the original date of service. Then There was in December of 2024, there was a mediation which occurred, and it says that there was no settlement, so the case was to be scheduled for trial. Okay? Did you go to, you had to go to the mediation because if you,
Saying that. The judgment was, I never knew the data that came out of that courtroom.
well,
Never knew. So how can I participate?
sir,
I just,
every time I go through something, you stop me and you tell me what you don't know.
Things spiral as the defendant keeps cutting off the judge. He keeps repeating, I didn't know. I didn't know. But after 22 years on the bench, the judge isn't impressed. The courtroom grows tense, and the audience can feel the frustration mounting.
I'm trying to tell you the whole process at once without you interrupting me to tell me that you didn't know. Because quite frankly, I think I've heard you 3 times when you told me.
Okay.
I didn't know. You've said it at least 3 or 4 times.
sorry.
So I do get that. Okay.
Yes.
Isn't that hard of hearing or anything? I think I got all my faculty still after doing this for 22 years. So I think I can understand your position. Okay. So on December 27th of 2024, there was a notice mailed by the court scheduling the small claims trial for February 3rd of 2025. That notice went to, well, I don't know why, because it was mailed. We can't take any, I mean, we do what we do. We don't know what the post office does.
Well, okay.
Okay.
There's no intent, there's no harm intended by me,
Sir, hold on.
and I'm getting punished for it.
Then on February 3rd, when you didn't appear, a judgment was entered after trial. I don't know what it was because it's not before me. So as far as I know, magistrate says after trial, she might have taken his proofs for all I know. I don't know what happened there, but it was entered not as a non-appearance default. It was not entered as a default. It was entered after trial. So apparently some testimony was taken or something occurred there. Okay? I'm just telling you what the judgment tells me. If it was just a default because you didn't appear, that box would have been checked. So the only person in this room that knows what happened is him. What happened?
Your Honor, we did have the mediation before the magistrate.
You mean the trial?
And they said that they would give us her verdict. That we could see verdict down at the window. They told us we could go home. They didn't have a verdict, and it said to call back. So I called back the next day. And
Okay, well, let me ask you, when you say you were before the magistrate,
Yes.
was that you and the defendant? Okay, it's because that's why it says after trial. And so she entered, and it says she corrected the spelling of your name too, to Thompson. And she did this judgment on February 3rd.
Yes, ma'am. After that, I waited for quite a while to see if he would pay. And then I filed for the subpoena to get the bank account information.
Okay, I don't need to know all that. I just wanted to know what happened. Was he there?
Yes.
Was there a trial? And you're saying there was. And she has an order saying there was. So this was, hold on, sir. This was not a default judgment because you came. Okay? It's not a default. Listen to me. It's not a default judgment. So the next thing that we show here is that the subpoena for the creditor's exam was done after the judgment was entered, which is what you're here for today. The first date was April the 25th. Not sure what happened there.
I filed paperwork.
Okay.
Your Honor, may I say something?
No, I don't want to hear from either one of you, quite frankly, until I finish doing what I'm doing. Okay? Notice of tentative hearing to the plaintiff. So then there was a notice saying that there would have been a hearing on April 25th if the defendant was served with the creditor's exam subpoena. Then it came to me, this is how I got involved with this, that the creditor, that there was a judgment already in place, that there was a creditor's exam scheduled on the 25th, but that Mr. Thompson insisted, is the language they use, on filing a motion to set aside a default judgment.
Because I got paperwork saying that there was a default judgment.
Okay.
Now the judgment itself is on full display, $2,627 owed. The judge makes it crystal clear. This was not a default. It was after trial, meaning testimony was heard. The defendant's pleas fall flat. The truth is written in black and white.
I then denied your motion, indicating there is no default judgment to set aside. This was a judgment after trial. If you didn't like the judgment, the proper remedy would have been to appeal, and the time for an appeal is over. That's what my order said, and I signed that on April the 25th. I don't know why you didn't get that.
Because I didn't have the knowledge of the judgment in the time span that I was supposed to submit, that I didn't agree with it, that whatever you call it, that I didn't have the opportunity to say that I don't agree with it. And then we go to, she told me that I could not agree with it afterwards within 7 days, and then it would go to a judge. She worked for a judge.
She works for me.
Okay. All right.
And every other judge in this court.
Way out of my realm.
Okay. But I'm just telling you that your motion you saying it wasn't fair. It was. You had a trial. She entered a judgment. The judgment was mailed. Go back. Give it to him. This is your judgment. It says, after trial, Mr. Brewer was awarded a judgment of $2,500 in damages, $127 of court costs, total judgment $2,627. Says that you must pay him in full, says there's no installment payment. That's why he set the creditor's exam to see where the assets are so that he could try to collect his $2,627. You two are free to work out some other type of a payment arrangement where you don't have to go through all of this. But that's what you're here for today. You're not here to object to anything because there's nothing to be objected to.
Right. I feel that I'm getting.
Sir, why don't you do this?
What?
You have to go to the creditor's exam. If you feel that you have something else you could file, why don't you talk to a lawyer and see?
I'm on disability. I don't have resources. This is exactly what he said when he said he was going to sue me. He has the resources. I don't. He does this.
Okay.
I don't. So, I'm
Sir.
getting stopped by a bully.
Stop. We don't do that in here. We don't call names and we don't
But
speak.
that's what his tactics are.
But we don't speak to the person. You speak to me. Okay, so calm down. So he has a right to bring a lawsuit if he wants to.
Yeah.
He collected on it. So I understand how you might feel because you don't want to have a judgment against you, but you do. And let me, sir, let me say this. I got another case, so I'm not going to go back and forth with you all day. But what I am going to tell you is this. From what I see, there's nothing wrong with anything that happened here. If you think that you have something that you would like to bring before the court, you probably need to talk to a lawyer about it. And we have information for legal aid. They may be able to assist you. They may not. I can't speak for them because they have their own intake process. He's going to get you information as to the phone number to them. This is a sheet that we give out in our civil cases for landlord tenant, but you're welcome to take the sheet. It's got the phone number on it. Call them, talk to them about what happened, but Now you've got the story. Do not give them inaccurate information because I just gave you the accurate information. Yes. And you got the copy of the judgment now, and you can tell them how you say you didn't get it, but we've got, and I will give you this too. I'm sorry, Charles, you might have to go back. I will go get you this, which is, I'm going to give you also a copy of the notice of hearing that advised you of the court date, which he says you were at. So
I was at the court date, but they told me it was a magistrate, and it was a magistrate.
it was.
She
And then-
did not let me know afterwards, like she said she was gonna. They said that they were gonna mail it to me. That's where the problem is.
Okay, well, the judgment went out to you.
How many days after?
February 4th of 2025. Look at your certificate of mailing on the judgment. Okay.
So it showed up like a day or so before. That doesn't give me 7 days to go. I'm not intelligent in this stuff. I gotta do research. I needed the whole 7 days.
The courtroom nearly explodes as the defendant claims he only has $75 and no assets. But the judge isn't having it. She warns him, ignore a subpoena and you'll face contempt of court, even jail time. This is pure legal reality check.
I can't, my glasses are all scratched up.
Okay. But I've given you everything that you need to give to the lawyer and discuss whatever it is you would like to discuss with them to see if they think that you have a basis to bring some type of question for relief to the court. But right now you got to do the creditor's exam because the judgment is good.
Well, I don't have any assets and I don't have my bank
Sir.
account. I didn't know I was coming here for that.
So
I don't have any money in the bank. I
Okay,
got $75. That's it.
let him. I'm not conducting the creditor's exam. He is. Okay, so stop. Turn around. I'm going to swear you in. Raise your right hand. Are you testifying or is he testifying?
Oh,
Do you solemnly swear or affirm that the testimony that you're about to give in this creditor's exam will be the truth, whole truth, nothing but the truth? Okay, I'm going to have Charles take you back out. Now that you understand what has happened and what you may need to do, you need to go ahead and conduct the creditor's exam. You have a valid court-ordered subpoena. So if you don't do it, you might be in contempt of court. And I know you're not trying to cause problems. You're just trying to get some clarification. So go ahead, do the creditor's exam. Let him ask the questions and then go to the lawyer and see what relief that they might be able to help you with. Okay? All right, go ahead. Yes, sir. What is it?
Document saying that no lawyers would be involved in this. The magistrate had us sign those documents. Okay. Either on a lawyer going.
Okay, but that it is, sir, it is small claim. It doesn't mean he can't go and have a lawyer help him prepare a document. They can do that. They just cannot appear in the case. So you are right. Okay,
Sorry for that.
no problem. Okay, and then I'm going to ask these creditors exam people why they're back.
Your Honor, we went out to the room out there, I asked Mr. Thompson the name of the bank, number, and he told me he doesn't have it yet. He said he can't get into his app because he's locked out. But I told him that doesn't prevent him from telling me the name of the bank.
Sure does not. You have to tell
He
him.
knows the name.
Sir, let me tell you how this works. He doesn't know anything. He has a right.
It's old Kent. It's a different name.
He has a right to ask you to respond to his question. He may think he knows and could be wrong. So he has a right to get the information from you and you have a duty to respond. Or you might be in contempt of court for failing to respond. Yeah, I know that, but you just got to tell him the name of your bank and the name of and the account number if you got it.
I didn't know I was coming for that, and I can't get into that.
So you got, how did you get here today?
I took the bus and walked
Okay. And so why did you come since you didn't know that you were coming?
because I didn't come one time, and I'm in a mess of trouble. I'm trying to get out of it.
Okay, so you came pursuant to a subpoena, did you not?
That's right.
So the subpoena told you, did it not, what to bring?
Okay, I got two different papers. I got one saying The one that you read me, the 2,600.
Mm.
And then I got a paper saying that this was supposed to be a trial, I thought. So I thought that my set aside.
You didn't get that.
Huh?
You didn't get a notice saying this was a trial. No, you did not.
Okay,
I went
that's
through
the way that
I went through everything that you got, and you did not get a trial notice.
That's the way-
You got a creditor's exam subpoena. That's all you got.
Okay, so I didn't understand. I thought it was a court date that I was coming to, honestly. And otherwise I would have brought because I.
Okay, so we're gonna adjourn this creditor's exam and continue your subpoena. And you're gonna bring everything that the subpoena said you're supposed to bring. Which is, let's see.
You postpone it for 60 days, I'll have it paid out by the time I come back in.
Do you want 60 days to see if he pays you?
That's fine with me.
If he pays you, you don't have to do any of this.
Okay.
When the defendant begs for more time, the judge reluctantly grants a 60-day continuation. The message is clear: pay up or prepare for harsh consequences. This is the breaking point of the hearing.
Flip on.
Excuse me.
Not doing it. All right.
Keep doing that, you get arrested for contempt of court in front of me, and I can hold you up there for at least 30 days. The subpoena asked you to bring bank statements and account numbers. That's what the subpoena says. You have to have the subpoena somewhere at your house, right? Because that's why you came.
Well, I had it at the house and I have Rottweilers.
What does that have to do with anything?
Okay. Okay, for real. For real, this is real.
Okay, Charles, go. Oh, I'm going to give you a copy of the subpoena, sir. I expect you to comply with it. Lock the dogs up. Lock the dogs up. Keep your paper separate. So we're going to adjourn this creditor's exam. Hold on just a second. So you got to look at what it says, bank statements and account numbers. If you do not want to do that, you need to get it paid.
I'm selling my house now. So I'm gonna pay it.
Okay.
It went on, I had somebody in my house within an hour. So, and I respect you.
Thank you. Okay, so what's the next date? We have 60 days out.
Court's available July 17th at 1:30.
You be finished with your house sale by then and ready to pay?
I got 30, I'm accepting, a lady came, it's really sweet, I'm selling it to her, I gave her 2,000 off just because.
Okay. So we will continue the subpoena until July 17th at 1:30. The court will send the notice. And I'm telling you now, so don't tell me you didn't know.
I know.
All right, because we're talking about it, right? So I'm going to tell Mr. Brewer, if he pays you before July 17th at 1:30, you need to call my assistant and let her know that you want to cancel the creditor's exam and you need to file a satisfaction of judgment. That is a form that says the judgment was satisfied.
Yes.
Okay, you got it? And that way he'll be done with you and you all can go your separate ways.
And that wraps it up. The judge shows firm control while the defendant scrambles for excuses. The lesson: courts don't bend for disorganization. If you enjoyed this intense showdown, make sure to like, drop a comment, and subscribe for more dramatic courtroom breakdowns.